Hi everyone. So I started at Stanford 2 years ago working with Mark Blumley, and I think I was there about 2 weeks when we decided that one of the first things we're going to work on together was to create a data set to try to comprehensively categorize patent owners and lawsuits and go big every lawsuit over a period of time. The reason, the need for that is somewhat obvious to all of us. First couple talks we had in this session, lots of other talks in this conference. There's, 30 people in this room. There's probably 30 different views on the impact of MPs on innovation. We also see it's pressing where last 3-4 years there's been legislation introduced specifically to try to curtail MP enforcement activity. And we believe that empirical analysis of litigation statistics does have the potential of informing the debate about MPs. But what we've seen, and I think this is still true, is that the work so far, the empirical work so far either uses proprietary data, RPX, that we're not able to verify the reliability of that data, or data capturing only part of the whole picture of NP versus P litigation. And so we see Michael Ridge's paper, which is actually a very good method of matching, having a match sample with all the litigation ever filed by the 10 most litigious NPEs. That match sample is really helpful for what he's doing in that paper. Kesson, Katropi, and Schwartz, looking at all lawsuits, but only for over 2 years. And Chen, these are just different examples. Chen looking at high-tech patent suits over a 10-year period. And then smaller or different data sets that were used in the papers presented today. Now, these are all these papers are very useful and very valuable to me in what they do, but when you're looking at a small subset of the data, it's going to be impossible to draw bigger conclusions about the impact of entities overall on innovation, and also be able to analyze any time trends. So for that, I think we need to have a data set that we can categorize who the patent owners are in every lawsuit over a period of time. And that's what we're trying to do with the Stanford Litigated patent owner data set. We are still, I'm very much, this is my latest idea for the name of this data set. It's kind of clunky, so the suggestions for a better name, I'm definitely open to those. So what are we doing? We're categorizing this data set the initial patent asserters in every lawsuit filed since 2000, which not coincidentally is the beginning of Weston-Agne's coverage. As either a practicing entity or as one of 11 categories of NPEs. And what do I mean by initial patent asserter? I mean that this is an infringement action. Who are the parties that are bringing the infringement action on the initial complaint? If it's a declaratory judgment action, who owns the patents that the DJ plaintiff is suing? And the taxonomy we use is an adaptive version of that created by Lemley and Mervold and used in Elson, Lemley, and Walker's most litigated patents papers. I'm going to get into those categories in a second, but sort of overall goals of the project, try to create as objective categories as possible, which is a huge challenge. Something I look forward to some suggestions, especially on a couple of the smaller categories. We still probably have some time to make a tweak here or there. Make the data publicly available, important for all of us in the room, and also hopefully for policymakers in Washington. And then we're thinking of this as something that's going to be continued. We're going to continue to add on to it over time to keep it current once it's complete. And so our categories, we have a number assigned to each category. You'll notice that I do not have these in order 1 through 13, and the reason for that is maybe if you just look at the names, you can get an idea of what the categories are. The first 4 rows, the left and the right side are sort of pairs of types of entities. So you'll see category 8 for some reason. I don't know why it wasn't 1 or 13 mark. This is right in the middle. Category 8 is our practicing entities. Number 12, IP subsidiaries of product firms. So if it's like AT&T IP1 or something, a separate subsidiary of a practicing entity that holds the patents and is the named party in the suit. So in each suit, what we're looking at is we're looking at the named parties that are associated with the owner side of the V, and we're giving one code, 1 through 13, to each one of those named parties. The next row, university, government, not-for-profits, we call sixes, and then university heritage or tied. That is like Wisconsin Alumni Research Foundation. The next row, individuals, which are mostly individual inventors. We also lump in if there are trusts that are asserting the patents on behalf of a deceased inventor. And then individual inventor started firms. So these are licensing firms that are owned by inventors. The next row, startups, pre-product, and then failed startups. So we can tell that there was someone that they were a startup they were thinking that they were going to produce, and then went out of business before they did it, and then asserted their patents. That's a 3. Corporate heritage are firms like Texas Instruments that we view as moving from a product firm to a patent enforcement business model. Industry consortiums, like standard setting organizations, very few of those. 13 corporate inventor started firms, and these are other taxonomies generally refer to these more as technology development companies. So the idea here is a 13 versus a 5 is that the 13 is, this is probably the most difficult category to sort of think of, to consider objective, because in a sense is this a bona fide technology developer? The evidence we look for that is, okay, it's a company that exists, develop technology in-house, not only to monetize patents. Some evidence, some conclusive evidence we think is, do they have ongoing relationships with practicing entities, exclusive licenses for their technology. And then down below is, in the bottom left, is one of the most important categories, acquired patents. So these are also licensing firms, but ones where the patents that the firm owns were not, the inventor is not one of the owners of the firm. So occasionally these are large aggregators and also just smaller licensing firms. And then undetermined, we've tried to avoid as much as possible in the data set.
So where's IV?
Intellectual ventures would be in one part. Yeah.
Or do they claim to be developing patents?
So we just don't believe them, I guess.
So, I think part of the problem is, right,
But I thought it's been from Revolt's methodology.
he is in fact spending money to do that, and they have generated some patents, although I don't know that they have asserted any of those patents. Part of the difficulty is, right, companies or organizations are sometimes going to cross these categories, right? So, you could be sort of somewhat of an 8 and somewhat of a 13. And we have actually,
Yeah, it should be probabilistic.
well, we've put some in more than one category, right?
Not entities. No, we pick one number for every entity. And I guess, the only response, I guess, is, okay, so if IV is actually the named plaintiff, we should switch them to 13s, but then, as Robin's paper suggests, we have all these, IV owns some hidden shell companies, so all those would be ones, I guess. And then
I solved that problem by identifying core activity.
Correct.
So within those, what is your core activity?
what's
So
your
if you're IV and you have, 60,000 patent families, and you've got 10 that you invented, the 10's probably not your core activity.
Good question. Sorry.
that's all right.
What's the difference between 12 and 13?
So 13 would be, it's a standalone company that they're just an R&D tech development firm.
The 12s are basically the tax dodges,
Yeah.
right? So,
Right, well, because that's like Monsanto's IP.
Monsanto's IP, separate IP.
So 13 is like interdigital?
Yeah.
Okay, I've got it.
Okay, so, at the beginning of the project, we actually started at the beginning with asking
Fellow scholars that have created data sets for their own work, FD data sets, if they would be willing to contribute their data. So we could sort of try to use that to help build our data set, and many people were very willing to do so. Of course, Mark was willing with his work with Ellison and Lemley. Colleen Shannon provided her data. Dave Schwartz provided their 3D data from basically their coding for all 2010 to 2012. Of course, their taxonomy is a little different than ours. So what we did is we used that in Michael Rich as well, and we've used that as some evidence for how we would code the case. If there was multiple academics that said this is a practicing entity, in that situation we just hook it as the practicing entity and left it there. We use that information, Lex Machina, the PTO patent, and also the science database, very helpful for this, and lots of Google searches. And I get more into details on how we did, how we go about some of those difficult searches, offline or in Q&A. What we've also done is we created a practicum course for Stanford JDs, and these of course are RAs that actually get their own credit. So the question is, okay, so you have RAs that are doing 95% of the coding here. That's probably exaggerating, probably 80% so far. And how reliable are those? First of all, it's amazing being at Stanford having an RA that has a PhD in chemistry and has worked in the chemical industry for like 3 or 4 years. One of my first quarter RAs, Vikram Iyengar, I think, is an electrical engineer, worked for, I think, Microsoft for 8 years or something like that. And so what we did is we would sick those students on cases that would be in their areas of expertise. And actually had another student who had worked as a summer clerk the summer before for Apple, specifically looking at their NPE litigation. So we said, okay, look at all the NPE litigation for Apple and code in the way you think they should code it. And then the other thing is, so we, of course, it's like a layered QC. So I basically assigned a batch of about 200 or 300 cases to a student. When they complete, I had a couple students that have been helping me for over a year now. Those students I'll have to do a QC of maybe 10% of the coding. And when there's disagreements, I look at those disagreements, and then we communicate among the whole group where the disagreements were, where the errors were. The biggest thing for reliability is eventually this, we'll be doing more QC before we release the data, but once it's released, all of you who disagree with our coding choices can let us know, and over time, the data should be more and more accurate. So far we've coded over 28,000, nearly 42,000 lawsuits filed between 2000 and the end of Q3 2013. And as I sort of suggested, with our RAs, our coding, our selection of cases of code has not been random, which has meant that even though we had 2/3 of the cases coded, we can't really use all 2/3 of those cases for a lot of analysis. And I realized that at the beginning of this year, and so we focused on working backwards from the most recent cases and coding those, and we've now coded substantially everything from 2011 on. And also in the last month, I've coded myself a random sample of 2,000 cases filed in 2000, and it's 20% of the population, so I think it's a pretty good sample size. Next steps over this next academic year, to code all lawsuits from 2010 to 2015, which is not going to be as big of an issue job as you think. Code a large random sample, so maybe a 20% number for all the earlier years, and make the work of the RAs a little worthwhile by helping them draft a white paper, a policy paper, and hopefully give them an opportunity to present that to policymakers. And then, of course, Mark and I are going to be working on a deeper multivariate analysis using the data. And then after we have our draft, the data will go online. It will be we'll have something online by this time next summer. I'll make the commitment today. So hopefully Congress can't do anything until after the next presidential election, and then some fun work to do ahead of us. So we do have some preliminary results at this stage. A couple of things I need to explain. So for 2,000 above, total coded cases 459. That's 20% of the total filed that year. Right, so this is the random sample. But what I did is I multiplied the counts by 5 to give an estimate of what 2000 would look like in entirety, broken down by entity category. 2011 and 2012 are basically complete. This one's a little lower because these are the last things we've worked on, and the database hasn't updated yet, or it didn't update when I downloaded the data. So we're missing like 150 cases or whatever. 2013, because we only have the first 9 months roughly, so these are not the full counts for the year, and the percentages are more valuable to look at. Of course, we're straddling here the AIA. You see our category 1, which are these licensing firms that are not connected, not owned by the inventors, but still in 2000 they represented 3% of all lawsuits versus 78% for practicing entities, or 8 of all lawsuits in 2000. By 2011 that was 23%, 2012 37, 40, 2013. And again, and the same thing we see with the inventor-owned licensing firms has jumped quite a bit. I found the individual inventor results to be pretty interesting because it started at 16% of filings back in 2000, and you see it sort of progressively shrink. The 9s, and then the 9s only. So these are lucky. So in many cases you have multiple entities on the patent owner side. So if there's only a 9, there's only one individual inventor. This would be maybe there's a 9, an inventor and a product firm that are both asserting the patent. The same over here as if it's, so we have some where we have a licensing firm and a practicing entity as well. And these are the only categories that I included because the other ones basically only show up 1% or fewer of the lawsuits. So that's an interesting thing is we have 1, 2, 3, 4, 5 or 6 of our 13 12 categories seem to matter in more than a very small fraction of the cases. So to sort of look and see, let's see if we can get rid of the AIA effect. Change between 2000, of course we have nothing, that's no random samples yet, even though lots of coding done for 2001 through 2010. Let's look at the first half of 2000 versus the first half of 2011 before AIA was enacted. Most interesting thing to me here is if you look at the raw number of lawsuits for producers, it's basically flat for 2000 to 2011. Whereas the licensing firms, I guess here from 95 cases to 450 cases. And that's before AIA. So seems like there was a big increase in licensing firm litigation even before the new junker rules went into effect. And I've also decided I have here, I wanted to see, okay, who actually sort of changed their behavior in response to the AIA. So we have first half of 2011 on the top, second half or entirety of 2011 on the bottom. And just looking at percentages here, the big change here was in the licensing firms that acquired their patents from third parties. Their share of filings in the second half of 2011 went up substantially. So they seem to be the ones that are most affected by this. Individual inventors, it's basically exactly the same percentage of filings. So they weren't, they didn't really change their filing behavior in response to the AIA, at least this year. So here are some and all these results are very preliminary, of course. I'm really looking forward to seeing the full trends, those intermediate years between 2000 and 2011. Same as, this is especially true here, I've also coded about 95% of the lawsuits that I had in my most litigated patent paper. Have used our new taxonomy to determine entity status. And in that one I figured out, okay, I had captured whether or not, captured elements. So did the owner win the lawsuit, by which I mean their patents were found valid and infringed? That's a 1-0 dummy variable. It's 0 if they lost on either infringement or validity. And when we look here, from 2000 to 2009, eights, when there was a final judgment, eights won 40% of those, whereas these other non-practicing entities won more like 20% of cases that had a final judgment. And I included 6, which is university. I don't know why it was only 5 cases, but it was so interesting. It was actually statistically significant. They lost 0 of the 5 cases over that time period that went to a final judgment. There's actually probably more, like I said, this is really probably 85% of final judgments during those 9 years. So that's what we have now. The thing that I'm most interested in is, so we're going to have these time trends. I think we're really going to see a takeoff in filings for certain types of entities over this 15-year period. And the question is, what do people think that means? Is it actually a problem? I mean, it's just going to depend on what we think of NP patents and some other things. What other controls when we're looking at this type of analysis are going to be most important? One of the things I think is most important besides technology, Michael used in his paper was the origin of the patent, because I thought he found some pretty interesting results, and that's something a lot of the work so far has not utilized, but I think that's something that we're going to need to try to get forward as well. Thank you very much.